Welcome everyone to the second in the Garden Court series of webinars on neurodivergence in the justice system. I just wanted to introduce very briefly before handing over to Mark the reason for bringing this series of webinars together. The idea was to try and bring together experts and practitioners from different areas of the justice system, different specialisms: crime, immigration, family, civil, people who practice, academics, other people with experience of the issues, and to examine where the justice system was getting it right in relation to neurodivergent participants, where it was getting it wrong, and how we might be able to affect change for the better, whether that be at an individual level for practitioners dealing with individual cases, or in making connections through this series, building bridges, learning from those other areas of law, and working together to improve things on a broader, bigger level. So that is the hope that may come out of this series. As I say, there are a number of further webinars to come. If you want to join up to those, if you haven't already, then please do check out our events page. Also has another number of other webinars that Garden Court are putting on lots of different topics that you may be interested in. But as I say, it's the sharing of that knowledge, information, and experience which I think is really key behind improving things in the justice system. And I know that Mark is going to make mention of some of the projects that people have already been in touch about, the research that's going on, and other events. So if there is anything that any of you are involved in of that nature, then please do drop us a line. So having welcomed you all and introduced this evening's webinar, I'm delighted to hand over to Mark Robinson, who will be your chair for this evening. Thank you very much.
Welcome to you all. Pleasure to have you all here for the neurodiversity webinar. And this is the second part of the neurodiversity webinar series. Well, this webinar will discuss representing neurodiverse clients in the areas of crime and immigration. We're going to be assisted tonight by the wonderful Neurodiversikey, a leading psychologist and academics in the field. Neurodiversikey is an organization dedicated to neuroinclusion throughout the justice system at all levels and from all perspectives, from law enforcement and to the judiciary. And it's hoped that this session will draw on the panel's experience in representing youths and vulnerable adults and a variety of mental health and neurodivergent learning difficulties who require an intermediary. We also hear from academics on their associated research in this field. Many thanks again to you all for joining us. Hopefully you'll get a lot out of this session. So first up, we have the Neurodiversikey team. We have Emma Llanwarne, who is the co-founder of Neurodiversikey and is a consultant criminal defense paralegal who was also called to the bar in 2022. And she's joined with the co-founder, Danielle Gleicher-Bates, and she is also a bar vocational student and a double scholar at the City University of London. So without further ado, I will hand you over to Neurodiversikey. Thank you.
Thank you, Mark. Emma and I will be giving you a whistle-stop tour of neurodiversity, beginning with terminology and individual neurotypes before focusing on ADHD in police custody and finally looking at intersectionality. On the first slide, we have a very brief overview of the terminology that we use when talking about neurodiversity. So neurodiversity encompasses all of the different forms of neurocognitive functioning across humanity, which includes both neurotypical and neurodivergent. Neurotypical describes neurocognitive functioning that falls within the range that society deems typical, whereas neurodivergent describes neurocognitive functioning that falls outside the range society deems typical, and so it's therefore deemed atypical. A neurotype is the term for a particular form of neurocognitive functioning or brain wiring, for example, neurotypical or neurodivergent. Neurodiverse describes a group of people which is made up of more than one neurotype, for example, a mix of both neurotypical and neurodivergent neurotypes.
ADHD is mainly associated with differences in attention, activity, and impulsivity. Autism is mainly associated with differences in social communication, social interaction, and processing information, including sensory information. The next four all come under the umbrella of specific learning differences. Dyscalculia is mainly associated with difference in understanding numerical information. Dysgraphia is mainly associated with differences in written expression. Dyslexia is mainly associated with differences in processing information and language. And lastly, dyspraxia is mainly associated with difference in coordination and movement. Focusing on ADHD now, we recently co-authored ADHD in Custody, a guide to police custody for ADHDers, and that's in collaboration with the ADHD Alliance. The guide is aimed at detainees in police custody and provides basic information about legal rights and ADHD, which include reasonable adjustments and appropriate adults. The guide has also been commissioned for use as an educational resource by the National Appropriate Adult Network to raise awareness and understanding of ADHD among adults and appropriate adults. But why ADHD, I hear you ask? Well, 25% of people in the criminal justice system are ADHDers, and this is likely to be an underestimate. ADHD medication also reduces criminality in ADHDers, and the research has shown a 32% reduction in men and a 40% reduction in women. Finally, ADHD costs the criminal justice system £11.7 million every year, a figure which would no doubt be lower if individuals were diagnosed and received adequate support before offending. Where ADHD is not appropriately accommodated and considered in police custody, there's a risk of evidence being deemed inadmissible and even miscarriages of justice. Unsupported ADHDers who are likely multiple neurodivergent are at risk of being misunderstood and unintentionally harming their case. The impulsivity, restlessness, and inattention characteristics of ADHD can manifest as false confessions, whereas commonly experienced anxiety and low self-esteem can lead to overcompliance, with ADHDs going along with anything that others say or do. In the police custody environment, emotional dysregulation and impulsivity can make it especially stressful and difficult to acclimatise, and ADHDers may respond disruptively, adopting unhelpful coping mechanisms. In police interviews, ADHDers are more likely to have difficulty, both practically and emotionally, to respond, don't know, and to answer questions vaguely, with the risk of this being misinterpreted as avoidant, dishonest, and uncooperative.
However, when we look at ADHDers in the criminal justice system, we can't just look at their ADHD in isolation, which is where intersectionality comes in, a concept which was developed by Kimberlé Crenshaw. And intersectionality is a lens through which we can view an individual's social identities, and in particular the ways in which those identities overlap and interact and impact one another. Intersectionality is a crucial part of understanding and supporting individuals. It enables us to identify the unique barriers, the injustice and the discrimination that they face based on those identities. And where an individual faces injustice and discrimination on the basis of multiple social identities, we term this injustice squared, injustice cubed, etc., as appropriate. Here are some examples of the social identities in the form of ice cream scoops, which illustrate how those identities interact and intermingle with each other. So here we have sex, disability, class, culture, race, and LGBTQIA+. But what's the relevance to ADHD? ADHDers in the criminal justice system are likely to face injustice and discrimination on the basis of multiple social identities, resulting in disparities in ADHD diagnosis, support, and treatment, as well as in policing and the criminal justice system. For example, women are under and misdiagnosed due to male-centric diagnostic criteria and male-centric research. And in the CJS, unlike men who kill their female partners, women who kill their male partners mainly do so after suffering abuse at their hands, yet only a tiny minority of 7% are acquitted on the basis of self-defense. Similarly, it's thought that Black youths are underdiagnosed as ADHD, but they're more likely to be misdiagnosed, including with a more severe diagnosis. And in the criminal justice system, Black ADHD youths are more likely to be incarcerated than their white counterparts. And finally, ADHD diagnosis has different consequences based on an individual's socioeconomic status. For children with lower socioeconomic status, diagnosis can perpetuate disadvantage, whereas for children with higher socioeconomic status, their parents may be able to provide accommodations, resources, and other assistance. In the criminal justice system, those of lower socioeconomic status are overrepresented throughout. Thank you.
Excellent. Thank you so much, Daniel and Emma. That was absolutely brilliant. And of course, intersectionality is a key word. Now, we move on. So next we have another expert in the field, Dr. Anne-Marie Day. She's a criminology lecturer at Keele University and also has many years' experience as a practitioner, a policymaker within the criminal justice. Immediately prior to this, Anne-Marie completed a research study funded by the Nuffield Foundation. The pathways into and out of custody for children in care was something that Anne-Marie had some research on. Anne-Marie also completed a PhD at the end of 2018, which considered the pathways into offending for children in care. In addition to this, Anne-Marie gained several years' experience teaching a range of criminology and criminal justice modules in a number of different higher education institutions. Anne-Marie also has many years' experience as a practitioner and policymaker in a range of criminal justice roles. She is a qualified probation officer and has worked in the community, courts, and prison. Anne-Marie has also worked as a youth justice manager and for the Youth Justice Board as a senior policy advisor in the areas of prevent, looked after children, domestic abuse, and antisocial behaviour. Currently, Anne-Marie is a board member on the Alliance for Youth Justice and is an expert advisor to the Howard League for Penal Reform, the Youth Justice Board, Cheshire Youth Justice Service, and the Home Office on various youth justice issues. What an introduction. So, Dr. Anne-Marie Day, the floor is yours.
Thank you, Matt. Gosh, that makes me sound like I've been doing lots of stuff. Can you not tell I've got ADHD? Always bouncing around everywhere. But no, thank you for that. Thank you for the introduction. So yeah, my presentation is very much focused on children in the youth justice system, and just some of the evidence and the research that I've done and others, just to hopefully give you guys some helpful and handy advice really about how to represent neurodivergent children in the youth justice system. There's my email if anyone wants to get in touch with me. So what we're going to look at first of all is, what do we mean by neurodivergence or neurodiversity? I'm going to skip over that a little bit because I think it was covered in the last presentation really well. I don't want to repeat ourselves. I'm going to look at what the legal protections are for children and also what has been said in various treaties and international conventions about children within the youth justice system that are neurodivergent. I'm going to just do a little bit of myth busting or myth debunking around neurodivergent children, because there's a lot that we hear, as in our professional practice and also amongst the public, and I think it's important that we unpick some of those. Then I'm going to look at the overrepresentation of children in the youth justice system and what does the evidence say. before moving on to police station, courts and custody, and then I'll hopefully give you guys some pointers for good practice or further information for children, and what specifically, if you're a solicitor, do you need to consider when representing children. So quite a lot in 10 minutes, eh? So here we go, just bear with me. It's a good job it's been recorded. So I'm going to just move over this because, again, I just want to make it clear that we're using the term neurodivergent or neurodiversity because often people have more than one condition. Even though they may have one diagnosis, it's very likely that somebody may have ADHD or traits of ADHD, but also they may be autistic. They may have some elements of dyslexia, etc. And just showing the overlaps in so many different areas of these, I think, is really important. And I've taken this slide from some work that Amanda Kirby has done, just to show the kind of huge overlap and nuance in this area. And I think it's important that we acknowledge that and we recognise that in the work that we're doing as well. So what are the legal protections? Well, the obvious one is obviously the Equality Act and that duty to provide reasonable adjustments and that kind of public sector equality duty that we're all bound by. And that includes people that are neurodivergent, that have hidden disability. And I'm going to make reference to that later on in the presentation because a recent National Autistic Society report directly considers how reasonable adjustments can be made throughout the criminal justice system for children. And it actually gives some really helpful and handy hints and tips that could be easily made at very little cost to help meet the needs of the neurodivergent population of children and adults. And it's important that you guys are aware of that. As you obviously know, Article 6 of the European Convention and also Article 40 of the United Nations Convention on the Rights of the Child guarantee this right to a fair trial. But often the definition of that and what it means is not clearly spelled out. So, you know, a fair trial includes this idea of being able to participate, and effective participation in a criminal trial. But the scope of it, as has recently been highlighted by Sixsmith in the forthcoming book around neuro law, remains unclear. And this has led to concerns that particularly for children in the youth court, that their rights cannot be, and this right to participation cannot be effectively safeguarded. But, you know, just stepping back and thinking about it in layman's terms, what does effective participation mean for children? Well, surely it must mean that they can follow what's going on, that they can understand what's going on in court, that they're able to express their views, and that a judge is properly able to take their views into account. So again, just thinking about the extent to which that happens for all children, but in particular for neurodivergent children who will struggle with that processing of information, speech, language and communication skills and so on. And in 2016, when Charlie Taylor was asked by the government to review the youth justice system as a whole, what he said when looking at the court was that all children are often the passive recipients of justice. They don't understand the process to which they've been subjected. In addition, the way that they're currently dealt with in the courts does not provide sufficient opportunity to understand the causes of their offending. And this was a sweeping statement that was made for all children within the youth court. So we can only presume that for neurodivergent children, these challenges will be even more acute. The UNCRC has also said more recently that actually when we're thinking about children with developmental delays or neurodevelopmental disorders or disabilities, the argument is actually, and the challenge to the UK and to other justice systems, is whether these children should be in the child justice system at all, or should they be dealt with by a more welfare-based system, such as a civil family court that considers their behaviour. And it's certainly something that the Carlisle inquiry have become frustrated with, and the lack of progress since that in 2014. The Sentencing Council guidelines for children as well states that, you know, children with speech and language difficulties and the effect that this may have on the child, and the court should take account of that. And they should also take account of the extent to which this impacts on their ability to communicate with the court and understand the sanction imposed. And I know from my own experiences working as a youth justice officer in the court and also a probation officer, I would say, and also speaking to children and observing since then, that there isn't a great deal that is done to take account of this at the moment, and that often we do have some assessments of speech and language needs, but in very, very few cases do I see that actually filtering through to any meaningful adjustments taking place within the court or any other legal settings. And then finally, the very recent case of Z.A. versus R reaffirmed this by stating that when sentencing a child, this means taking care to explain the reasons to them in words that they understand. So again, you know, when we think about, you know, magistrates in the youth court typically, and the way that they speak to children and how things are explained, it's extremely variable. You know, long sentences are used, lots of information, it's not broken down, there's not that checking in to make sure that they understand, it's not provided in writing. So are children really taking this on board? Chances are they're almost certainly not. So that's just some of the legal protections. So before I move on specifically to look at children in the youth justice system, I just want to look at some of the myths that exist and that some of you may be thinking around neurodivergent children, or you may have heard. One of them that we often hear is it's a fashionable excuse for poor behaviour. It's just the latest label for naughty children. And as I've put there, you know, this is very much an assumption. It flies in the face of physiological evidence in terms of the brain and how it's wired differently. You know, neurodivergent children, as it says there, tend to display disruptive or challenging behaviour when they're triggered in some way. So it's something in the environment that they're in that is overstimulating, stressing them out or overwhelming them. So rather than focusing on the child and saying, oh, this is the fashionable excuse for them being naughty, maybe what we need to do is step back and look at what is going on in that environment and their interactions that could be triggering challenging behaviours. It just makes us look at how an environment can disable a child rather than putting all the blame and responsibility on them. Again, there's often this idea, and I think there's been a question already in the Q&A about this, but the same set of adjustments or the same set of training can be helpful for all neurodivergent children. This idea of a one-size-fits-all. Hopefully from that slide I showed you a few back from Amanda Kirby, you'll see that that is not the case. Every neurodivergent person has their own story. We all struggle with different things and excel at others. And we all have traits that can seem contradictory. So, you know, we may struggle with, we might be able to hyper-focus, but then at times we can also struggle to get started and concentrate on some tasks. So it's not always consistent either. I've always heard this one, we're all a little bit autistic, or we're all on the spectrum somewhere. That is not the case. Autism is a neurodiversity. The brain is wired in a different way. You're either autistic or you're not. You can't be a little bit autistic, okay? And another one I've heard more recently as well is there's an autism epidemic. The evidence for this seemingly rapid change in statistics isn't so much that there's an epidemic, but it's that the understanding of it, the assessment of it, etc., is becoming much, much better. And actually the figures at the moment are actually becoming more and more accurate, and our understanding is evolving, which is a good thing. And that is probably part of the reason why we've got this wonderful series of seminars that are being put on by Garden Court Chambers at the moment. There's just some of the myths. There's many more, but I just wanted to pick out the main ones from my perspective. Thinking about children in the youth justice system, why is this an issue? Well, anecdotally, and also the limited evidence tells us that children are significantly overrepresented. Neurodivergent children are significantly overrepresented in the youth justice system. At least 1 in 3 people may be neurodivergent, but this rate is even higher for children with ADHD and speech and language difficulties. And actually up to 90% of children in custody met the diagnostic criteria for a communication disorder. 90%, and this was 7 years ago. So actually, when we're looking at children in the youth justice system, is this a minority or is this the majority of children in the system? Do we need to be really looking at this for all children that we're working with? Children and young people, as you are probably aware, in the youth justice system also have significantly higher rates of mental ill health, cognitive and neuro disabilities and complex support needs than the general population. So again, that intersectionality is really important. And the associated impairments, such as, you know, ASD, ADHD, speech language, traumatic brain injury, and also fetal alcohol spectrum disorder are also the significant overrepresentations, and there's some of the references there to support that. So we can conclude that this group of children or people are significantly overrepresented. This is why we need to think about, well, what can we do? So again, some of this has already been touched on on the previous presentation, looking specifically at ADHD. But thinking about children, research has shown that the police generally are not equipped to meet the complex needs of children. The custody suite processes are deeply unsettling for all neurodivergent people. The lights, the noise, the banging, the waiting, the unsettling nature of it can produce, again, thinking about how the environment can trigger and produce challenging behaviours. This is then misinterpreted by the police as non-compliant, which means you're less likely to then be offered an official or unofficial informal diversion. you're less likely to be bailed and more likely to be criminalised. And this was found by the Criminal Joint Justice Inspection in 2021. Other issues at the police station included the failure to provide an appropriate adult, or that neurodivergent adults and children then didn't have someone helping them with understanding the police processes or advocating on their behalf. Okay, so this is just some of the evidence that's emerging in this area. In the courts, well, there's evidence to show that all children struggle to understand the court processes, which is no great surprise. And the Carlisle inquiry, which I've already mentioned, 9 years old now. How much progress has been made since then? Not a great deal is my own perspective. There's been anecdotal improvements, but generally the youth court hasn't really shifted in its makeup or how it's run since its inception in the early 2000s. So they noted that children's mental ill health and neurodevelopmental disability further hinders the understanding, and there's no way to identify these, and we still struggle with this. Children are also more likely to be refused bail because they cannot understand the conditions, or they have a lack of support to help them comply with the conditions, or they're over stringent, often setting children up to fail. Children have often been found to agree to things as well. So, yes, I'll agree to this bail package, I just want to get out of here. I'll plead guilty because I just want this to be over with, without that understanding of the consequences of what this will mean. And for neurodiverse adults at court, they found that they were more likely to be remanded in custody before trial. Over a fifth didn't understand what was going on or why they were there, and that neurodiversity is frequently not considered in sentencing decisions. And then finally we get to custody. And for children, I mean, the custodial establishment for children at the moment and the secure estate is pretty shocking. You may or may not be aware, but the secure training centres that exist, most of them have been closed down recently as a result of concerns around children being locked up for too long in their cells, up to 23 hours a day on their own, accusations of abuse and neglect. And then the young offenders institutions are also coming under extreme scrutiny at the moment. But custody can be harmful to children's mental health. And what I've found in some research I've done and with others is that, you know, high levels of restraint, segregation, isolation can trigger mental ill health, self-harming and suicidal thoughts. And this is even more acute for children who are neurodivergent. I interviewed 48 children in custody. Around 20 of them were neurodivergent. A good chunk of them had ADHD. The behaviour management regime is based on the adult model, which is that, you know, you have to comply and you have to follow the rules. Children with ADHD struggled with that and were being disproportionately placed on basic, which is the regime that you go on if you're not behaving. And this would lead to children with ADHD being placed in an 8x8 cell for up to 23 hours a day, which would impact on their mental health, lead to frustration, more negative behaviours, and they would stay stuck in this vicious cycle. There's also been evidence and research to show that there's a lack of knowledge from wing prison staff about how to interact with children who've got mental ill health or neurodisability or special educational needs, and there's a distinct lack of training there. And there are assessments done when somebody goes into custody, but they are not filtered through to impact on how somebody is interacted with in that environment. What can we do about it? Well, there's some good resources out there, and I just want to highlight some of these and then give some specific advice for solicitors and advocates in the court and police settings. Firstly, intermediaries are available. They're not used as much in the youth court as potentially they should be, but there's some really good advice about intermediaries for child defenders on the Youth Justice Legal Centre website. And these slides are going to be shared, and there's links to all of these resources on this slide. But this gives you advice on how to determine if a child needs one and how to apply. There's also advice about effective participation and fitness to plead, again on the Youth Justice Legal Centre website. And these guides are really easy to read. They're about 10 pages. They're dead straightforward. They don't take a lot of time, but they just give some really good practical advice. I'm not sure if you guys are aware of the Advocates Gateway, but this gives some good practice guidance when preparing for trial. And this gives advice for children and adults, but toolkits 5, 6, 7 and 8 are particularly useful for children. And again, just about how to apply for intermediaries, different stages you need to go through and so on. I've already mentioned, but the National Autistic Society report, they recently did a review into the youth justice system for autistic teenagers, and they found that, again, the system is wholly unsuitable and it's quite traumatic and harmful for children. But towards the end of the report, they run through for police, custody, courts, all the different stages, including community supervision, a range of reasonable adjustments that could be made to help support children that obviously are protected under the Equality Act. And again, I'd urge you to take a look at that report. And then finally, there was some research done a few years ago with Nottingham University and Nottinghamshire Police, where they looked at a range of resources that could be made for autistic children and adults in the police custody suite around communication, the environment, and so on. And there's a link there on the slide that hopefully you'll find useful. So just to finish off, I'm not sure how I'm doing for time, hopefully I'm doing okay. But what do you need to consider as an advocate, a solicitor? I think firstly, the key is communication. If you've got somebody who's neurodivergent, and there isn't a one size fits all, but this is just some general advice, the things you need to think about are providing questions in advance in writing, in a similar way that is now being done for job interviews, the use of social stories, so like almost comic strips or YouTube videos to show somebody what will happen when they go into court, how it will work, the kind of questions that they'll be asked. And there's lots of resources out there that you can find. And again, when you're communicating, think about chunking information. And what I mean by that is one question, one statement at a time. Then allow somebody to respond to that, to reflect that they understand what you've said, and then move on. Because often we can say quite complex, long sentences without realising, and somebody's not taking that information in. And that visual guide as well can help with that. Check, double and triple check that somebody understands what you're saying. Often someone will just say yes, just for it to be over with, or they'll say I don't know, as was alluded to in the police interviews for children with ADHD. Think about the sensory environment as well. Is a child overloaded? Is there lots of lights, noise? Do they feel uncomfortable? Because if that's the case, then the thinking part of their brain will shut down, the amygdala will kick in, and they will not be able to respond in the way that you want them to. So you need to think about quiet, calm, non-triggering environments. And again, there's further advice out there. If the child's got parents, ask the parents. Often they're ignored as a source of expertise for the child. Ask them, ask the child themselves what works for them. They know what they feel comfortable with. If they've got an education, health and care plan or an SEN support plan in school or in college, get hold of it, because that will contain very, very detailed advice on how to meet that young person's communication and wider needs. And it may be quite useful for outlining how similar adjustments could be made in the criminal justice environment. And then don't forget the ground rules hearings. They're required in all trials where an intermediary is used, and they're good practice in all young witness cases, and in other cases where a witness or defendant has communication needs. And again, there's some guidance there in the Youth Justice Legal Centre. So hopefully that has given you just a little bit of a whistle-stop tour of just some of the things you may need to think about when thinking about children and neurodivergent children in the youth justice system. But if anyone does have any questions, I know we'll have time at the end, but I hope that you guys have found that useful. Thank you very much.
Excellent. Thank you so much, Dr. Anne-Marie. That was absolutely wonderful. Again, it was a wealth of information that you heard. Conscious of time, so we move on swiftly to Professor Claire S.Allely. She's a professor of forensic psychology at the University of Salford in England and is an affiliate member of Gleicher-Bates Neuropsychiatry Centre at Gothenburg University in Sweden. Claire is an honorary research fellow in the College of Medical and Veterinary and Life Sciences affiliated to the Institute of Health and Wellbeing at the University of Glasgow. Claire acts as an expert witness in criminal cases involving defendants with autism spectrum disorder and contributes to the evidence base used in courts on psychology and legal issues through her published work. She is author of the book, The Psychology of Extreme Violence, a case study approach to serial homicide, mass shooting, school shooting, and lone act terrorism. And this is published by Routledge in 2020. She's also an author of the book Autism Spectrum Disorder in the Criminal Justice System, a guide to understanding suspects, defendants, and offenders with autism, also published by Routledge in 2022. Without further ado, I hand you over to Professor Claire S.Allely.
Thanks, Mark. It's a real pleasure to be here amongst such great colleagues. And the topic I'm going to really focus in on today is how a person with autism might be misperceived or misjudged in the courtroom. So how a autistic defendant might be perceived as by jurors and judges in a very negative way. So we've had a lot of really good discussions so far, and I think a lot of what we've heard already from our colleagues about ADHD is also applicable here to autism. So there are a number of features of ASD that might make a defendant appear really evasive, remorseless, lacking in empathy, and guilty. I've lost count how many times I've heard as an expert witness that a person with autism was like a psychopath. They were really cold, they didn't care. And I think this is really important to really unpick. Is it the autism that's causing them to present in that way? So there's a number of features that we'll all be very commonly familiar with that can lead someone with autism to be misperceived. So this is difficulty making eye contact, making it or maintaining it. And that again can make a person with autism appear really shifty and guilty. They can't look their alleged victim in the eye, for instance. Echolalia or repetitive vocalizations. This is where a person with autism may repeat what they've just heard. And that can be like seemingly like an agreement to what's just been said when they actually don't, or it can just be perceived as being very aggravating behaviour. Issues with time to respond, again, is another very commonly known thing. This is where a person with autism often sometimes needs more time to kind of process the question and to generate their response. And again, in a police investigative interview context or courtroom context, this can be misperceived as the person trying to make up and fabricate a story in their head, which is why they're taking a longer time to respond. There's also the misinterpretation of repetitive interests or behaviours. So if they're sitting in the courtroom, rocking back and forth, reading something, engaging in something, this again can be misperceived as being not caring about the process. And rather than actually they're needing to do that to maybe calm or soothe themselves down, or because it is part of their restrictive interest, but they're still engaged in the process. That's some of the kind of more commonly known ones. I'm going to now focus on some of the maybe lesser well-known features of autism that can make them appear really negative in the court or be negatively misperceived. So the ones listed here in bold, I'm going to go through each one. I'm speaking very fast because I'm conscious of how much I've got to say in a short space of time. So for me, one of the really critical ones is the issues that have been found in many people with autism. And there's been some great work by Katie Myers and colleagues who have found that people with autism often need longer time to remember things. They often need to have much more probing. They often rely much more on familiarity in order to guide their memory and recollection of those events. They also can have difficulty with remembering certain aspects of memory. So people will remember the capital of England is London. However, only a small number of people will actually remember when they actually learned that information. So there's actually two different types of memory. One is the knowledge-based information, the names of cities, and that's called semantic memory. And the other type of memory is memory for specific episodes or events, which is called episodic memory. So what's been really interestingly found by researchers like Katie Myers and colleagues is that people with autism often tend to have a spared or intact memory for semantic things, their general knowledge-based information, whereas they tend to be often more impaired in their specific episodic memory. So remembering specific episodes of things or events, they tend to take longer to retrieve these. They need more prompting in order to do so, and sometimes they can't remember them at all. So this is really important if you could think about a courtroom context or police investigative interview context. When a police officer or asks, tell me about what happened that day, they may struggle to remember the events, what happened in what order, but they'll remember very specific knowledge-based things like what they wore or certain things that were said or what they ate. And again, police can find this really weird. It's like, how can you remember that level of detail for such innocuous, semantic-based information, but can't remember when it was he did it or what was the episode, what was the event? So people with autism need much more time with which to remember things. And again, this can appear very negative. Another thing that's relating to this is people with autism have been found to have overall more impaired ability to remember the sequential order of things. So remember the temporal sequence of narrative of things they've experienced. So again, how negative this can be perceived if they're asked, right, take us through everything that happened that day. Start with breakfast. And they might, throughout that sequence of events that occurred that day or over the weeks or months, might say things really out of order, but really believe that that's the order they took place in. And each time they're asked, they may present that information in a completely different sequence. And again, this can be really negatively perceived in a criminal justice context. It is relating to their difficulty with actually remembering the sequence of events rather than deliberately trying to be evasive. And that's indicative of that the lies, effectively. People can also find it very challenging to remember how long specific events were. So this is like effectively time perception. So if they're asked, how long do you think you were in the park before you then went into the pub? Or how long do you think that was you spoke to that person? They may often really struggle with this type of questioning. And again, this can really look very negative. Another thing I think is really important to look at is how a person with autism may have no emotional expression on their face. So as I mentioned earlier, this can make the person seem like a psychopath, when the alleged victim's talking about what they've allegedly done, and they're like standing there like not having any emotional expression at all. This can be really perceived as being really lacking remorse, and this can obviously have major implications to their sentencing, whatever. However, it's really important to recognise that people with autism, they often sometimes can have this lack of emotional effect, but it doesn't reflect what they feel inside. So inside, they may be feeling really stressed, really anxious, really upset about what's being said and what's happening, but not actually express it at all. To really confuse matters, you can also get people with autism that are the absolute polar opposite. They actually are very expressive, in fact, heightenedly so, to the point of being almost really dramatic. So I think it's really important to recognise just how autism can present in so many different varied ways. So if you're used to someone with autism who's very expressive and overly so in some respects, almost overly dramatic, there's also the other way where they can be the complete opposite. But again, it's not necessarily reflecting what they're feeling inside. So emotional expressions or behaviours, they may exhibit emotional expressions or behaviours that are totally inappropriate to that context. And they may have no appreciation about how it would be perceived by others. Like, actually, I better not do that. I better try not to do that because how others might think that has been very negative. And it's really important, as an example would be if you're ever in a situation where you're really, really stressed, like say for instance, you're at a funeral and sometimes you're so distressed that you almost have a sensation like you want to laugh, but it's the last thing you want to do. I'd like to argue here that this is what some people with autism may feel, that it's totally incongruent to the situation, but it's like almost like a defense mechanism. They're confused in the situation, don't know what else to do. It's overwhelming. So they sometimes engage in these unusual, inappropriate behaviours. And again, how negatively this could be misperceived in a courtroom context. They may burst out laughing, they may sit and grin, but it may be serving a completely different function for that person with autism. Another thing is unusual ways of speaking. So some people with autism may speak very monotonously, with no intonation, no variation in their tone. And again, this can make them seem really cold and psychopathic in manner. They may also all of a sudden speak out very loudly and all of a sudden shout for no reason. Again, this could be misperceived as being aggressive or angry. They can also often, seem really, aggressive or odd when they all of a sudden speak really loud and they all of a sudden speak really quietly. So they might, vary between the two. And again, this can make them seem like they're trying to hide something, or they're being deliberately, challenging in the courtroom. Another thing is the issue with compliance, and this is something some of our other colleagues mentioned earlier in this session today, and it's also the case of people with autism. We do tend to see they're much more heightened in their compliance aspect. They're not more suggestible, but they are more compliant, more eager to please, more likely to try and do things that will avoid confrontation. So this is like the thing I mentioned earlier on with people with ADHD, that they may say things in order to avoid that situation, and this can even be false confessions or saying things that can be self-incriminating just to get out of that situation as soon as possible. There's also issues with mistrust and paranoia. So it makes sense if you have someone with autism who has maybe had a lot of difficulties and challenging social interactions where, you know, they thought that this person was a friend to them, but actually they learned that they were just abusing them and exploiting them. And so they may have interactions as well where they interact with someone and they've said something wrong and it's led to an altercation. This can over time lead to people with autism being very mistrustful or very wary of other people, to the point bordering on paranoia. This can make them very mistrusting, very anxious in different social situations, including the courtroom. And when you think about it, some people with autism have really difficult, challenging abilities to understand what other people are thinking or recognize and pick up on emotional facial expressions, particularly negative ones. Why this could also lead them to be very mistrusting and almost paranoid of other people and what their intentions are. The last one is social communication and interactions. So they may all of a sudden interrupt the speaker, like say they're being questioned and cross-examined in court. They may all of a sudden butt in without recognising that's actually not the end of a sentence, or they may be very one-sided in their communication. I think it's really important to highlight here that this is not always the case. Some people with autism can actually mask or camouflage their social interaction difficulties or challenges. And I really recommend a questionnaire called the Camouflaging Autistic Traits Questionnaire. And this is a really great measure of self-report where you can really see whether the person is engaging in any of these camouflaging behaviours that includes imitation, masking, assimilation behaviours. And some people with autism are really, really good at this, to the point where they appear to recognise and understand everything that's going on, but actually they may only be getting the gist in that particular negative, challenging situation. So I really recommend that tool. People with autism can also have difficulties with metaphors, irony, non-literal language as well. But again, the camouflaging if they engage in that, they may hide that challenge that they're facing. So I've really gone through very fast here. I don't know, I didn't set the timer, but I welcome questions at the end as well. So hopefully it's just given you some insight here into some of the challenges that some people also face in the courtroom. I probably have spoken too fast there. But I reckon I can send resources and slides and a link to the Camouflaging Autistic Trait Questionnaire because I think it's so valuable. It's been found to be a valid and reliable measure as well.
Now we're moving on to our next expert, Dr. Max Lowenstein, who is a principal lecturer in law at Bournemouth University, a non-practicing barrister with an expertise in legal communication, inequality and diversity, disability law. Max is a socio-legal academic with a passion for exploring comparative criminal justice. His research teaching interest areas include criminal law, comparative law, sentencing law, evidence law, public law, legal practice skills, jurisprudence as part of his research and teaching efforts. He's also travelled widely in Europe to the Netherlands, Denmark, Germany, and England to both expand his knowledge of criminal justice issues and to share his ideas with his fellow academics at various conferences. So without further ado, Dr. Max Lowenstein, please, the floor is yours.
So thank you for that introduction. Yes, I teach at university and do various criminal justice talks on neurodiversity, frankly, to anyone who will listen. But I have done talks or helped review for the CPS on their mental health policy, helped the Magistrates Association with a talk on neurodiversity in the courtroom, and assisted Parliament too. I'll get on to Parliament actually towards the end. You'll also see on the introductory slide that I do charity work. So I work for a charity, Action for Neurodiversity, which looks to help and assist autistic clients with counselling, and that work is very important to me as well. Beyond that, my research is in adult and youth justice, mainly sentencing, and currently I've now diverged into equality law and employability with autism employability, and the global picture too, which that's interesting. What I will cover with you today is these three main points that are on the screen. On the first one, on disability awareness, this tends to manifest itself around challenging mental health stigma, and the important first hurdle, frankly, of actually disclosing a disability. And some people do. I do. I have autism, anxiety, and depression, but many don't. And as they're hidden disabilities, you will never know unless they're disclosed or you find a report somewhere for your client. Beyond that, secondly, I'll talk about reasonable adjustments, the equality law regime, which puts that central stage. The issue, though, is the application of the reasonable adjustments and the understanding and the listening to your client to be able to do that. And that is not easy to do. And you may note that I put criminal and civil justice system because disability and neurodiversity does not respect systems or services or boundaries at all. It is inherent to the person that you're dealing with. Thirdly, I'll talk about sentencing and best practice, and I'll reflect a little bit on the research that I've done into sentencing communications, which can be very tricky and challenging when you are dealing with neurodiverse clients or when judges have neurodiverse defendants in their court. But just to start, the overall duty in equality law is very, very broad, very, very broad indeed. But under Section 149 of the Equality Act 2010, as public authorities, of which legal services and courtrooms are part, there is this duty, a very strong duty, to eliminate discrimination, harassment, and victimization and advance equality of opportunity and foster good relations. So it's a very, very broad duty and a very powerful duty. And you'll see actually in the slide here how wide that is. Just on the Equality Act itself, the protected characteristics, we're only talking about one aspect of it, which is the disability side, but there are many others. And of course, someone will have a disability and they will have gender, they will have sexual orientation, all the rest will go with it, which can obviously add to the complication. What can further add to the complication is how you view neurodiversity as a whole. So this slide really covers a lot of aspects of neurodiversity here, you can see. However, as has been alluded to with other speakers, we have interlapping conditions that people have. If you have autism, you may well have anxiety, depression as part of your sensory sensitivities and just dealing with the world, of which I deal with that every day. And these are not easy conditions to understand, and I think it's important for people to recognise that, to try and boost their understanding via charities and via various other mechanisms, but it's a challenge to do. And then just from a specific neurodiverse conditions perspective, you can see with autism itself, all of the different conditions. So this slide covers quite a few conditions. Interestingly enough, they are not all neurodiverse. Some of them are physical impairments as well in this list of conditions. So, for example, development coordination disorder, or DCD, on the list. That one is a physical impairment. So they all vary in terms of the impact and they interlink together. Now, when they get to the courtroom, they've gone through the police station, they've gone through the CPS charging situation, and then they're going to go to the courtroom. And what's been found there? Well, S.Allely et al., a Cambridge study last year, you can see the quote here. It says that they found there were significant problems with the implementation of reasonable adjustments in the courtroom. And this was an analysis of 93 cases that they looked at. And you can just see in the picture below, without reasonable adjustments, that's what the ladder looks like with no rungs. With reasonable adjustments, that's what it looks like if you do them. So they are tremendously important. And I'm finding this actually in my employability research, that it is exactly the same picture, whether it's in the employment picture, whether it's in the criminal justice system, civil justice system, anything you like. The adjustments are just so important. What did S.Allely et al. Actually find? Well, they said only a quarter, 25% of autistic people, which they looked at, were given reasonable adjustments, with 38% not given any, even though the lawyers stated this would have been beneficial to them and that they're entitled to it under equality law. Of the autistic people who went to trial, more than 1 in 5, or 22%, were not given any reasonable adjustments, even though their lawyers stated this would have been helpful. Although on a positive note, they later on found in the study, in the cases that where their client was found to have committed a crime, 60% of the judges saw the defendant's autism as a mitigating factor, and in these cases, the majority of autistic people were given suspended or reduced sentences as a result. So quite significant impacts there. But beyond the statistics, there's a much more complexity going on an individual basis between the lawyers and the clients, and particularly the defendants in the courtroom. The pushback on reasonable adjustment is legitimate, and these 4 areas in green are what they are. And it's got to be cost effective, and it's got to be practical to actually implement the change. From the employment perspective, they can push back on it, and from the service perspective as well, they can make these arguments. And it is important to see the other side of the coin, that we want to make adjustments. I'm sure all of us would agree with that, but there is a resourcing issue that is acting here, and we need to be aware of that and try our best to be cost effective in everything we do. So then we get to the actual courtroom and misperception or misjudgments that you could potentially get. Now, this is a list that Claire's spoken for me from Claire's book. What I'd like to add to that is that the adversarial system, and I say this to my students, is incredibly stressful and confusing. Well, don't take my word for it. My students report this to me every time they go to a courtroom, and they, first-year students and law students, that's the impression that they get. I've seen it many, many times when I've gone to court, usually representing myself. And one example I give to students is that I saw a bunch of builders, burly builders, I call them, and I've never seen them look so scared in all their life. And I said, what's going to happen? Oh, we're going to be going through cross-examination now. And we are scared. So it is incredibly scary experience. Now, add to the list that somebody's got a neurodiverse condition. It doesn't take a genius to work out that not only are they going to manifest different behaviours, as this slide shows, but the stress of the whole situation is also going to manifest. That's if beyond their understanding. Beyond that, in the courtroom, there's a lot of body language going on, which impacts how judges perceive matters in the court, as well as the juries. And so guidance and understanding for judges and juries is very, very important. How would body language manifest itself? Eye contact, voice tone and pace, the emotions and understanding, which Claire has so skillfully talked about earlier. So then we get to the practicals, really. What can we actually do? Well, I actually, the grid that I'm going to show you, this was actually adapted from my own inaccessibility to a major publisher. And what I did is I actually produced this for people trying to publish their work, because if you have neurodiverse condition, it affects, as I said, everything you do. And this I adapted for the courtroom. We can see here for dyslexia, for example, the difficulties they would have, the challenges, but also the solutions. And this is very, very important, that we understand the condition, listen to the person, but then we provide solutions that will assist them. And I've put here some solutions, for example, with dyslexia, to ensure that the speaking task or requirements within the courtroom are clearly and logically structured and are explained succinctly to the person, and offer one-to-one support. Some of you will be saying at this point, one-to-one support, well, if that's practical, if we can fund this, but we should be doing it because we want to include, and we know the equality law specifies that we should do this. And dyspraxia, the same sort of thing. I've put some examples here of what that means and what you can do in the courtroom, frankly, to help the person. And with dyspraxia, for example, the planning and organisation in their life can be affected, and that can be assisted. We can see in the first point there on the slide, with clear guidance on what is to be expected, not only inside the courtroom, but before they go into the courtroom itself, so they can be prepared. So there's lots and lots of practical things as lawyers that we can do, and as judges who are in charge of the courtroom, that we can do to make that experience just so much better for the client, for the defendant that we're seeing. Moving on to other conditions within the courtroom, we can see, for example, autism at the top there in blue, and we can see the main ways that can manifest. I mean, that's by no means an exhaustive list, so I've simplified it. But sometimes simplification can really help people's understandings. And it says, just in the first point, use of plain language and structured logically and sensitively. Now, in the use of plain language, this is very much enshrined in sentencing, but what might be plain language to you as an individual may well not be a plain language to the person involved. And certainly in teaching, I experience this every day, how simple and plain my language has to be, frankly, so that people understand. And the use of visuals as well can really, really help with that. ADHD at the bottom here, the impact of it in terms of challenges, and then the solutions, which is so important of what you can actually do. And the second point there is about drip feeding and simplifying the task to complete bit by bit for the courtroom user. Now, I would like to say that I produced this guide simply by scanning the internet, finding the charity best practice, and creating this grid. It didn't take me too long to do, and it's something that you can do in your own time. You want to, just to educate yourselves, frankly, about each condition, because they are complicated, and for the clients that you have. Moving on to the sentencing side of things, well, Section 52 of the Sentencing Act is very clear. There's a duty to explain sentencing in ordinary language to your client. But what does that actually mean? And that can be complicated, I suppose, depending on who you have in the courtroom. And as we've discussed, you can say to the client or defendant, do you understand? They might say yes, and they actually don't. By the way, this happens with my students a lot of the time, particularly the neurodiverse students that I know. They will say that they understand, but they don't. And then I have to sort of probe them almost to get that understanding, to the same level that I have. And repetition actually can be very, very important in the processes you apply with your clients and in the courtroom. The judges themselves are very much aware of the duty to make reasonable adjustments. Of course they are. It's within the equal treatment bench book, which they take very, very, very seriously. So judges are very open and I want to make as much adjustments as possible to assist all courtroom users, of which they are in control of that courtroom and have obviously the quality or duties too. Beyond this, we then get to the sentencing explanations that they give within the court. Now, these are complex, globally significant, and they have a unique disabled courtroom user impact depending on what disability the court user has. So in my research, I've covered the adult sphere, which tends to be the negative side of sentencing remarks, what I call adult denunciation or public condemnation and blame. And I've put in the publications for that, which actually was a comparative study with Denmark, of which Denmark was a lot nicer in simple words than in the UK on adult denunciation. And then on the youth perspective or youth system side, how you communicate. I looked at it from the judicial perspective in my research. And as part of that research, what really stood out actually beyond the language simplification for young defendants was the moral re-education element, of which could be completely lost on a neurodiverse court user. So retraining on this and knowing what that means and explaining that in a way that a neurodiverse client or defendant will understand is just so important. It was certainly deemed important when I did the research for the judges when they sentenced morally re-educate some of the young offenders or young defendants. But again, if it's meaningless unless the defendant themselves, their parents, their proximate relationships, the youth offending service, etc., understand and can then continue that moral re-education, as I found in my research, beyond the courtroom. So beyond that, we then come towards the end of my slides. We talked. I did actually a search on equality. I was interested to find out what the equality picture was if you sort of searched it on. I've got the link in there for the Sentencing Council. Various offence-specific guidelines came up. You can see the list there, but that was about it. And so I think there is work that can be done. The Sentencing Council's own Equality and Diversity report and response in 2023 stipulated the bullet points below. They talked about aggravating and mitigating factors, and we've said that neurodiverse disability often is mitigating, but it can sometimes in case law also aggravate, depending on the context of each case. And then beyond that, the importance of pre-sentence reports was picked out, and then the collection of data, frankly, for judges' directions and then sentencing explanations. So I recently did a report, or contributed to a report for Parliament on public understanding of sentencing, of which it was found to be that the public don't understand sentencing very well at all. And I just added in my inputs that have you thought about the equality and diversity impact as well? Because I suspect it's a lot worse there. So there's work to be done to improve things. Now, I'll tell you a funny story. When well, not so funny, but some of you might find it surprising, but in the process of actually engaging with Parliament, I asked for reasonable adjustments and I didn't get any, or they weren't implemented very well, which then led to a complaint. And the reason I'm telling you this is to say that even our own Parliament can make mistakes on implementing reasonable adjustments. And if our own Parliament, who implemented the very statute, the Equality Act 2010, can make mistakes, of course we can all do so. The important thing is to learn from those mistakes and improve the system, which is what I did in my feedback. And they accepted that, which is a good story to end on, that they needed to actually improve their inclusivity and the use of adjustments to include me within their select committee work. So that brings me to the end of my slides now. I don't know, I was supposed to start my timer, but I didn't, but I hope I'm to time for everybody.
Thank you so much, Dr. Max. That was one. Now we move on to our final guest, maybe one of our most esteemed guests of the evening and panelist, Garden Court's very own Amanda Weston, KC. Amanda is a leading public and administrative law silk. She co-authored Judicial Review, a practical guide available on LexisNexis, and is a member of the A panel of preferred counsel who act for the Equality and Human Rights Commission. Amanda has acted in hundreds of asylum and human rights appeals, including high-profile and sensitive cases and those involving extradition. Her cases include gender and sexuality cases, complex political and religious cases, and appeals for children and vulnerable adults. Amanda also acts in cases in the family division, administrative court, and the appeal courts where the rights of children and young people are in play. Her particular areas of crossover expertise involve safeguarding local authority, corporate parenting duties, education and disability, deprivation of liberty, immigration and citizenship matters, and sensitive cross-cultural areas including FGM, radicalization, trafficking, and forced marriage. She operates a trauma-informed practice using her extensive extensive experience in mental capacity law and safeguarding practice to inform her approach to the representation of vulnerable adults and their litigation friends in a whole wide range of cases. Another great introduction. So Amanda, it is over to you.
I'm really grateful to all the participants so far, because I've learned a lot, and I've also seen where there's some overlap with the what's in this PowerPoint, which is a very long PowerPoint. It's actually a set of training that I delivered with my colleague in the family team, Amanda Muse, on what the current practice is in the family courts when faced with individuals who have barriers to effective participation. And that's really the focus of what I want to sort of sweep up a bit, because I'm not going to go over ground that's already been gone over by the panel. I think it's fair to say that the family jurisdiction is sort of in the vanguard of finding solutions to barriers to effective participation, and is quite forward thinking in the approaches which are taken by in the family courts. And so I'm going to be suggesting that there is some read across into other jurisdictions, and we can all learn from good practice in any aspect of the justice system. Again, my focus is very much not on diagnoses, but definitely on barriers to effective participation in any proceedings. And I'm actually going to go a step before that and say that there is already good practice and judicial recognition that evidentially, to get the best evidence, to make sure that evidence isn't skewed or distorted by the effect on access to the justice system, access to effective participation, to ensure that the evidential basis isn't skewed, and that the best evidence is obtained, and to protect the integrity of that evidence, then consideration has to be given to ensuring that reports which are before the court also, and I'm thinking not just about courts relating to competence, but in the family jurisdiction, we're often looking at parenting skills, parenting abilities, and so in circumstances where the court is looking at a person's ability to perform a parenting role, or indeed any role or any function, it's important that those who are assessing those abilities for court purposes also ensure that their means of gathering that evidence takes account of the impact of neurodiversity on providing the right information and communicating the right information so that the court has the information that it needs. Page 5, please. Please, Amy. So just a quick look at the legislation. So obviously, under the Equality Act 2010, judicial functions are exempt from prohibition on discrimination, but it's important to note that that doesn't that only goes to the core judicial decision making, not the ancillary functions around the arrangements made by the court, the arrangements made by HMCTS. And then, of course, when we're dealing with the sort of the legislative framework, we remember that the non-discrimination provisions of the Human Rights Act aren't bounded by the same sorts of legislative carve-outs as the Equality Act is. And therefore, that even if you can't run an Equality Act type point or use the Equality Act as a lever, that's not to say that you wouldn't be able to do so under the Human Rights Act. And obviously, in the context of family, we're very much dealing with the overlap Article 8, procedural safeguards, Article 6, and Article 14, discriminatory failure. So just to check the equal treatment benchmark again, it's important to note that document, which is available online, is a huge, great big thing, but it's intensely useful because it does contain the sort of up-to-date approach of those who train the judiciary. And I think it's fair to say that not all the judiciary all the time are terribly up to speed with what's in it. And it's important to recall that there's been some quite forward thinking already in the senior levels of the judiciary about the impact of failing to make adjustments to the process on the quality and integrity of the evidence. And it's important, I think, to remember what the former Lord Chief Justice said, which is that the truth is the objective. So getting to the heart of the evidence, making sure individuals are able to give their best evidence and the court is able to get to the truth of the case is the key underlying prime mover in ensuring that the appropriate adjustments are made. So, and again, we have some useful dicta there from the M case, which is sort of 11 years old now, and does give an indication of the extent to which the family courts are already alive to the problem of caused by barriers to accessing the process. So just a few more interesting little bits of dicta. So in the context of the family jurisdiction, the family proceeding rules and the accompanying practice directions already make quite detailed arrangements, in addition to the overriding objective, obviously. But the practice direction 3AA in the family proceedings rules makes it quite clear that the court has a general duty to identify any party or witness who's a vulnerable person, and to consider specific arrangements like screens, like intermediaries. In practice, that normally means that there will be a report followed by a community court report, followed by the parties usually agreeing what measures might be necessary. The other panelists have already gone over those in detail. I don't intend to repeat them, but it's important to note here that in contrast to some other jurisdictions, including the immigration courts and tribunals, the family court is all over the idea that it's for the court to ensure that it has properly considered what adjustments should be made in order to ensure that the court can guarantee and protect the integrity of the evidence. And it points out here that it's important that those issues are identified long before any proceedings are started. In the context of public law proceedings in care proceedings, obviously then it's for the local authorities to ensure that when they're making assessments and when they are considering taking legal cases against parents in respect of the care of the children, that they themselves have taken appropriate steps to ensure that their decision making and that gets the parents into court in the first place is properly informed by adjustments to the process of gathering information about the children, their welfare, and the parents' ability to parent them. Could we go to page 24, please? Because I'm conscious that there's some parts that I want to highlight. And I don't have time to go through absolutely everything, but this is the D&E case, and this is really the courts highlighting the point I made previously about the integrity of the underlying evidence that the courts consider in the underlying reports. And it's here, this was an appeal which was allowed because the court had identified that it was an error of law, that there had been an absence of suitable, targeted and attuned assessment having regard to the mother's ASD, meant that the court could not attach sufficient weight to the community-based assessment or indeed to the social worker's parenting assessment. So it's clear here that the process, as I say, of gathering evidence which is then put before the court must also be properly informed by the sorts of adjustments that you've been hearing from the other panelists. Just looking at the issue of communication needs, it's important. Obviously, we've been looking at that with the other panelists as well. But it's important to see, and I think the family division and family practitioners generally are quite at home with these sorts of concepts. But it's the individual person's ability to communicate and to understand the process, which must inform the approach that advocates have, not only to representing them, but also importantly, ensuring that the way that information is sought from them, we talk about it in terms of questioning, but it's really more of a facilitation to ensure that the evidence comes out in a way which ensures the integrity of the evidence before the court. It's so as far as family practitioners are concerned, that assessment and that proper understanding of communication styles, deficits, skills, whatever language you want to use, is much more important than the identification of a particular diagnosis. And not only can the individual's communication abilities, I think, as one of the other panelists made absolutely clear, it's not just personal to that individual, but it's also situational. And being alive to the kind of pragmatic and practical solutions means that there are going to be individuals in respect of which bespoke arrangements are going to be necessary to be able to deal with that issue. And courts and family practitioners have been warned repeatedly not to get on tram lines or one-size-fits-all type set of adjustments when ensuring the integrity of evidence with people with those sorts of access to justice needs. So on to page 33, the question of vulnerability, it can be too broad a term, but it is useful. Sorry, page 33, please, Amy. It is useful because it very much situates the kind of adjustments that might be necessary in their broadest context. So a good encapsulation of this is in Lord Reed's formulation in the Osborne and the Parole Board case in the Supreme Court. Justice is intuitively understood. That's the kind of intuitively understood is the kind of legal formulation that you can only get away with if you're in the Supreme Court. But anyway, it's intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions in the exercise of administrative or judicial functions. And that sort of underpinning formulation is good to bear in mind, and it's a good one to throw out to those individuals and public authorities whose job it is to fund and resource the sorts of adjustments that are needed. The next point I wanted to go on to is about the cloak of competence, which is a really interesting and, in my experience, helpful and useful concept for courts to get their heads around how individuals are presenting. So this is a term which was first used by Dr. Parsons in Re En a Child. Dr. Parsons had noted that one feature of the mother's presentation is that she initially presents as far more cognitively able than is the case. Now, obviously, a lot of the time in the context of neurodiversity, we're not strictly speaking about cognition at all, but we are dealing with, again, vulnerability and barriers to participation. And as the other panelists have made clear, the sorts of maladaptive coping strategies or even masking that clients can develop mean that an individual can appear that they're much more able to participate than they are in fact. And that cloak of competence is something, it's a concept that family courts are increasingly aware of, because in any circumstance where a person is under pressure to appear their most competent and credible self, the pressure to seek to appear and to sort of mask the difficulties that might be faced are obviously intense. And there has to be a way of an escape route for those participants in proceedings. And the concept of the cloak of competence is one which, if courts and representatives are sufficiently astute to it, can help a client to feel sufficiently safe in order to make those vulnerabilities known to the court. And for the same reasons, the family courts have noticed, and family practitioners increasingly are familiar with the concept that self-reporting will be unreliable, because individuals obviously choose not to disclose for fear of discrimination, ridicule, or a more punitive response. So the general advice is an advocate who suspects a witness or a defendant or a party in family proceedings or whatever proceedings should consider asking questions of that person's, asking appropriate others to make inquiries or to seek expert advice in an environment which is safe for that person and non-judgmental. I just wanted to highlight page 58, please. It was a very long PowerPointer. And it's right that we're all stressed when we go to court, but it's important to note that the cumulative impact of stress on individuals in the justice system, taken with everything else, can lead to very extreme stress reactions and avoidance. I just wanted to draw your attention to the advocacy toolkit, number 5 at 4.25 has got some really helpful guidance, practical guidance for advocates dealing with that sort of situation. So the rest of the PowerPoint really does sort of go into the sort of mechanics of the different sorts of modes that the brain can go into and put under particular stress. And I'm not an expert on that, and we've had some really good experts speaking about those practical difficulties and the practical impact of those cumulative matters. I think I would just say, page 84, please, that as professionals, that there are sort of a few, and a lot of us are legal aided, and we don't have a great deal of funding and time to cover the extent of the work that needs to be done to properly support individuals. But as professionals seeking to support individuals through what might be the most stressful time of their lives, that taking time to listen to learn about your clients, individuals, and what they want, individual needs and what they want, what they actually want, is a much better use of your time than reading what the diagnoses are, and planning your representation according to diagnoses. Do not immediately focus on criticisms. Think about the positives and how you can help. Going back to the issue about situational differences, asking your clients how they experience certain situations and how they react to in particular professionals can solve a lot of problems early on. You might have an individual who has found it impossible to be understood by somebody who is reporting on them, and if you've asked that question, they may not volunteer that information. You can't rely on self-reporting. If you've asked that question yourself, then there's a better chance that whatever report that's prepared in respect to them is going to be better evidence. Try to adapt your style to fit the client's needs, and think about preparing a one-page profile aid memoir for you in your file, so that you've always got it in the front of your mind when you're taking any steps in your client's case about what the specific characteristics are of that individual that make it difficult for them to access the justice and effectively participate in the process. That's all I had. I'm just looking at the time and thinking I'd better call a halt there. Thanks, Mark.
Thank you so much, Amanda, for that. Right, so now is the time where we're going to be delving into the Q&A and answering some of your questions. I am conscious of the time, so I'm not going to do too many questions, so apologies if I don't get through to you all. But first things first, a question from Alan, and he says he's interested in if any of the experts have had attended vulnerable witness training, and if so, what they thought of the guidance for dealing with neurodiverse people. And he alludes to it, saying it was pretty condescending with a one-size-fits-all approach. Again, the floor is open for you to take those questions, but I'm assuming vulnerable witness training is something that I suppose counsel have had to do. I know I've done it, and I'm sure Amanda has done it. So Amanda, maybe you want to take that question, unless any of you other guys want to answer it.
I think we're in the early days of this kind of training. I'm interested to know whether it was the family or the criminal vulnerable witness training that was attended, because I found the training run by the Family Law Bar Association really quite advanced compared to the criminal one that was at Middle Temple. And that's not to criticise the individuals that were running the training. I think everyone accepts that we're in the shallows of those sets of training. And yeah, I mean, I think one of the points about the cross-examination techniques in particular in that kind of training is that you've got a limited amount of time to get some very key points across. And I agree, it should be a lot more nuanced. And as I say, I think that the family law training has got a lot to teach other jurisdictions about more person-centred approaches to access to justice. So I agree.
Do you think that terms like disorder should be replaced with condition, as neurodivergence isn't an illness or disease? And that's from B. I've slightly rephrased that, but it gets to the point.
I was wondering if I could jump in here on that, because I'm probably
Yes.
know that I'm probably would be considered the worst offender in that regard in this panel session today. So I very deliberately, you'll notice I used the word person with autism or individual with autism. I know this is frowned upon. I do think that the National Autism Society had a study where it found that a lot of people, not the majority, but a lot of people with autism, certainly the ones that took part, which I would say would be a select group of individuals with autism, not representative of all individuals, do favour the identity first, so autistic person. I think in a forensic context, it's really dangerous and potentially damaging, because it gives over the impression that the person is unable to change. There's an inflexibility in both their attitudes, their behaviours, their motivations. And so I very deliberately use individual with autism, very deliberately, and also use the word disorder very deliberately as well. I know that, again, there's a favourability towards autism spectrum or autism spectrum conditions. Again, I think this is really damaging in a forensic context. If you're talking to like jurors and lawyers, no offence, judges who already have misconceptions around autism, like the ones we're discussed today, if you fling in it's a condition, almost demeaning it, devaluing it, when we're already kind of going on this idea that everyone's, neurodiversity and that, and everyone's somehow got autistic traits, I think it's really demeaning the disorderedness nature of it for individuals who've been so disordered or impaired that they've actually engaged in offending behaviour in the first place, largely. I actually was in a prison in the Midlands of England. Now, I had a luxury and joy of meeting with a lot of autistic prisoners there. And I asked them this question: what do you think about disorder? What do you think about individual with autism? And it was unanimous that they feel it's very disordered, it's very impairing for them, it's caused a big issue. And so I really do feel that it's really important to capture and be very nuanced as to the kind of populations we're talking about and dealing with when we use different terminology. Yes, neurodiverse is great, neurodiversity is great, autism spectrum condition is great in a community setting, but a forensic setting, my strong views are stay well clear. We're already struggling to get people with autism who's generally committed an offence because certain features of autism being a criminal, a vulnerability factor, provide that context of vulnerability. Let's not, in my view, further muddy the waters and make it, because I'm going to stop after this last point, but I've actually had cases where defence lawyers, obviously some are really great, some are less knowledgeable about autism. And I've actually had defence lawyers say the autism is immaterial to their defence. It's not important to look at in relation to their offending behaviour or anything in terms of diversion or lesion or anything like that. And that's because they have seen the person as being like, oh, everyone's on the autism spectrum, they're very highly articulate, very intelligent, and a very professional job. Yet, as I've already alluded to, this can often mask, and as Amanda also mentioned, it masks, this cloaking can really mask their actual impairments. And as Max also discussed, the anxiety that these situations provoke, it's overwhelming for someone with autism. I've heard it said again, I said that was going to be my last point, but I heard it said so many times, oh, but the courtroom's anxious for everybody. They don't know what questions are going to be asked. Yeah, but for someone with autism, it's much more intense, much more pervasive, to the point where they will struggle to think about what they want to say. They will miss out large proportions of what's going on around them, such as their anxiety. And I'm going to stop there and let my colleagues speak, but it's something I feel very strongly about, which is why I really wanted to come in there. And I know I'm not popular in that view, but I think it's really... Hi, Amanda.
Just to add, absolutely. And I think from a forensic point of view, as a practitioner, we need to move away from the idea it's about making people feel better. You can't make people feel better. All you can do is everything to protect the integrity of the evidence. And those are the steps which need to be taken.
Absolutely, Amanda. Can I just add in here, Mark, as well, that I was really saddened when Anne-Marie and some of our colleagues did a great day conference at University of Salford, tremendous presentations. And Dr. Luke Winter did a presentation, and I posted up images on Twitter about what he was talking about. And the diatribe about terminology, the vitriolic animosity that he received, when all he was doing was trying to promote understanding about people with autism in that prison context, people with autism that are engaged in sex offending, to try and really understand that. And I just thought, listen, guys, it was just sad to see, we're all want to do what we're doing today and further the knowledge and, make people also have more effective participation in their own trials and fair hearings, etc. It's so sad to see. Amanda, you're right. We need to move away from making people feel better and face, for people it is a disorder. It's very much
Thank you very much. Firstly, extend thanks to Neurodiversity is Key, or Neurodiverse is Key. Emma and Danielle, thank you to Dr. Anne-Marie Day. Thank you to Professor Claire S.Allely. Thank you to Dr. Max Lowenstein, and thank you to Amanda Weston Casey, and of course thank you to Amy Hughes for being the moderator in the background, and of course Tom Wainwright as well. Much gratitude to you for helping organize these sessions. So before you all go, there are neurodiversity webinar series. Of course, this was series 2. The up and coming webinars are, the next one is part 3. That's on the 23rd of January, 2024, almost upon us. And that's about witness handling. And that's shared by Amanda Weston Casey again. Part 4 is on the 20th of February, 2024, neurodivergent children in the justice system. Part 5 is on the 19th of March, 2024, neurodiversity in the criminal justice system. And final part 6, the last episode in the series, on the 16th of April, 2024, neurodiverse lawyers. There's also a wide range of events at Garden Court with free tickets available. And the next one's actually tomorrow, which is Tuesday, 22nd of November. That's between 1 p.m. and 5:30 p.m. And it's a hybrid conference about children's rights and children and detention. We have another one at Garden Court Chambers next week on the 29th of November between 6 p.m. and 7:30 p.m. It's a hybrid event as well. Illegal Migration Act Part 3, Third Country Removals and Interim Measures. On the 5th of December, between 6 p.m. and 7:30 p.m, we have hybrid training and Introduction to Nonviolent Resistance, NRV, or NVR rather, trauma-informed training for family practitioners and guardians. And on the 6th of December, between hours of 1:30 p.m. and 6:45 p.m, we had a hybrid conference, Brook House Inquiry, What Lessons Have Been Learned. So that's all of the events. Of course, all of the events that Garden Court does are on the website. We have a whole range of hybrid events, webinars, and lots of things going on towards the end of the year, and many more things going on into next year. So please do check out the Garden Court website. Again, we have to shout out various ongoing research projects. They need your help, guys. So we need some respondents and interviewees. The University of Bath are doing a new study as part of their Autism in Court project, where they're looking for respondents. They are also surveying justice professionals on their experiences of working with autistic people in court and tribunal proceedings, with a particular focus on giving evidence and the use of special measures. Of course, that's intermediaries. We are also running parallel surveys for autistic adults and friends, family members who have supported them through the court process. If you're interested in taking part, please do let us know. Information about how to get involved will be circulated in the follow-up email after the webinar. Also, Dr. Tom Smith, the University of West England, and Dr. Roxana Delhaganani at Cardiff University are also undertaking a research project about how autistic individuals access justice through criminal defence lawyers. They are currently looking to interview barristers, solicitors, and accredited police station representatives, also child legal executives, about their views, understanding and experiences of representing autistic individuals accused of crime in England and Wales. Interviews are voluntary, confidential, and would last around an hour, conducted by Microsoft Teams. If you are interested in finding out more about the project or being interviewed, information about how to get involved will be circulated in the follow-up email after this webinar. And of course, most importantly, slides. Again, there's been so much information that's been spoken about. There are toolkits and a full range of resources available to you. I thank all of you guys, all of our attendees for joining us, and we would appreciate your feedback, and a feedback form will pop up in the Zoom and when the Zoom ends. So please do fill this if you are able to do so. I know we overrun by 50 minutes, but I'm so glad that we had so much to discuss, so much information for you guys. I hope you found this session helpful. And again, I have to big up and give extended gratitude to all of the panelists tonight. Thank you, guys. This is the end of the session, and I bid you all have a good